Hello and welcome to this Community Legal Centres Queensland webinar. My name's Stephanie, I'm from Community Legal Centres Queensland. I'd like to begin by acknowledging country. Community Legal Centres Queensland acknowledges the traditional owners of the land on which we are holding this presentation, the Turrbal and the Yagara people. We pay our respects to elders past, present and emerging, and acknowledge the important role of Aboriginal and Torres Strait Islanders continue to play in our society. As this presentation is being viewed throughout Queensland, we also pay respect to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening to this presentation. We also acknowledge the disproportionately high rates of domestic violence experienced by Aboriginal and Torres Strait Islander peoples and the additional challenges this creates in responding to this issue. Please have a look at the important information that's come up on your screen now. It's a legal disclaimer explaining the purposes of this webinar and also our Keep Safe content warning. Some content in these training materials could be disturbing or upsetting, and we recommend that you look at our Keep Safe website page. The web address is at the bottom of that important information page. Today we welcome Jason Garrick, who's an acting senior lawyer at Legal Aid Queensland. He's working currently with the Counselling Notes Protect Service and the Violence Prevention and Women's Advocacy part of Legal Aid. Jason's a very experienced lawyer working in domestic violence and particularly as a domestic violence duty lawyer. So we welcome him today to talk to us about working together, the practical legal ethics of practitioners and others working together to get the best results for clients in domestic violence matters. I'll hand over to Jason now, who's going to acknowledge country and then talk about the aim of this webinar.
I'd also like to acknowledge the traditional owners of the land on which we will meet today, and particularly the Jagera and Turrbal people where Steph and I meet today. I'd also like to pay my respects to their elders, past, present and emerging, and I would also like to acknowledge the traditional owners of the land on which I grew up on, the Barada people of Middlemount, the Kungalu of Blackwater and the Darrumbal of people of Rockhampton. Today I'd like to hit first the aim of today's webinar. I'd like to build everyone's understanding of Queensland's domestic violence legislation. I'd like to explain the court processes and identify key stakeholders in the Magistrates Court of Queensland, and particularly where duty lawyer service and social work services work collaboratively with the courts. I'd also like to discuss some key ethical considerations in adopting a multidisciplinary approach to domestic violence matters. And I'd like to help partner with you to identify key resources to build your professional toolkit. Going straight to the legislation, anyone who works with people who live with violence, whether they be people who are survivors of domestic violence or potentially clients who use violence as forms of communication with their partners and people who are important to them, it's important to understand where the motivation of the Act comes from, and that is, of course, within the preamble. The preamble acknowledges that it is a human right to live free from violence and it's a fundamental social value. We identify that domestic violence is a violation of human rights and that it is not acceptable in any community or culture. DV is an expression of power imbalance. It results in one person living in fear. And I should say, while it says a person, this also extends to children and people who are vulnerable to domestic violence. It also acknowledges that domestic violence is gendered. The statistics do not lie. We do have to accept that the large majority of people who are survivors of domestic violence are women and children. And we also need to acknowledge that domestic violence is a leading cause of homelessness and serious physical, psychological and emotional harm in survivors, including children. I'd also like to bring everyone's attention to the objects and principles of this Act. Again, any lawyers who are listening to this webinar today, I can't impress on the importance of sections 3 and 4 in the way in which you deliver your services to your clients. The objects and principles of the DV Act is to maximise the safety, protection and well-being of people who fear or experience domestic violence, and to minimise disruption to their lives. It is to prevent or reduce domestic violence and the exposure of children to domestic violence. It is to ensure accountability of those people who use violence in their relationships, and to ensure that their actions and the impact of those actions, that they're accountable for those actions. I apologise, that's a poor turn of phrase on my behalf. And further, we also need to acknowledge that there are certain sections of the community who are vulnerable to domestic violence. Now, these are not limited to, but certainly include women, children, First Nations people, people from a culturally and linguistically diverse background, members of the LGBTIQA+ community, and the elderly. So today, the purpose of this webinar is not to give everyone a blow-by-blow account of how the legislation works, what the legislation does, and how you can wield the legislation to support your clients' needs of safety, or alternatively addressing how this legislation may impact on your client. Today, I'd like to acknowledge that there is essential knowledge that I'm assuming that people understand and are aware of. That is, what is domestic violence? So we know and accept that it's physical, emotional and financially abusive behaviour, it's controlling and threatening behaviour, it's exposure of children to domestic violence. Now, pro tip for everyone here is that I would really like everyone to understand and arm yourself with the definitions of domestic violence pursuant to the legislation. Print off the legislation, make sure that it's at the cover of, that it's at the front of your personal toolkit, which you keep on you or in your office as you deliver these services or potentially take with you to court. When a protection order is made, it's the 3 elements: relevant relationship, acts of domestic violence, and that it's necessary and or desirable for an order to be made. It's essential to understand that orders are in place for 5 years now, unless there are reasons given by the magistrates for an order of less than 5 years. I also assume that everyone understands the key themes and considerations of the court and the leading case law in this area, which of course addresses the issue of risk and risk of future violence, vulnerability, and history of domestic violence, and how a history of domestic violence may significantly impact on how and when orders are made. When you are supporting your clients, it's very important to understand who are the key players in the administration of this legislation. So it's important to understand that the Magistrates Court of Queensland has the jurisdiction to deal with this, and their registry staff are critically important in the administration of DV court days, making sure that the court is aware of issues which may impact on your client's ability to attend court, and ensuring that those messages are passed on to the magistrate to ensure that orders are not made in their absence. We acknowledge that domestic violence duty lawyer services are available throughout the state. For a comprehensive list, I do strongly recommend you reach out to Legal Aid, and you touch base with your local court to make sure you know who the people are, as some of those services are provided by preferred suppliers as opposed to legal aid officers. It's important that we know and we arm ourselves with the information around our DV social work services, including DV Connect, Men's Line, Centre Care, CARDA, which is Centre Against Domestic Abuse in Northern Rivers region of Southeast Queensland, and the others which are around in our regional regional workspaces. It's also important that we understand that the Queensland Police Service has a presence at court on DV DV court days. They include the prosecutor, our DV liaison officers, and our police volunteers. I'd like to introduce you to our client that we're going to walk through today. His name is Hugh Reynolds. He's presented to your service. The Queensland Police Service have served him with an application for a protection order. The aggrieved, Kate Morissette, has made a complaint to the police involving 1 count of strangulation, 2 counts of being hit with a closed fist to the right side of her face, and multiple text messages to her from Hugh, calling her names and making threats, including death threats if she seeks medical treatment or goes to the police. The Queensland Police Service were called by a Queensland Rail employee who saw the incident occur at 7 p.m. on Sunday night at Eagle Junction Railway Station. Hugh has previously disclosed to you and workers at the service that he has borderline personality disorder, a history of substance abuse, and schizophrenia. So, how do we support Hugh? Practically, before you take any step where you're working with a client who requires assistance, we must be aware of our client's confidentiality. The circumstances of the application should trigger some concerns before you even talk to anyone. There is a strangulation offence, that's a serious indictable offence. It is dealt with extreme caution by magistrates, and before you even talk to anyone about the matter, you should make sure that you have clear authority and boundaries about what you will discuss and what you won't discuss with any key stakeholder as you try to help Hugh work out when he needs to go to court, what information he needs to take to court, and whether or not you can provide an appropriate referral for Hugh to make sure that he has support when he attends court. Now, I'd also like to highlight that if you are getting an authority, make sure that you get it in writing. So Hugh has given you this police application. Now, you can see that there's a stamp on the front of it. For example, it'll say Redcliffe. So that way you know straight away that on the cover of the application that you know which court he's at. But because of the photocopy that you've received, it's not a very clear photocopy. You can't identify the court date. So you need to make sure that you give your client and give Hugh the relevant information or partner with him to get the information for him. You may choose to contact the court to confirm the details of his next court date. You might like to also ask the registry staff. You might say to them, excuse me, is there a duty lawyer service available to respondents on the next court date that you're aware of? And they will give you an indication as to whether or not they have duty lawyer services available for Hugh on that day. That may inform the steps that you take to support Hugh and whether or not you decide to write a letter to the court to outline the issues which may be affecting Hugh in the future to support his position around what orders are the most appropriate in the circumstances. You may also wish to provide a map to your client about how to get to court and set calendar reminders in their phone with them. And I always suggest this, and certainly when I work with vulnerable clients, I make sure I include a reminder the day before at about 4 p.m. so that I know that my clients can give me a call and say, oh, I've still got court tomorrow, don't I? These are the steps that can make a huge difference to a person like you who has presented with a few different vulnerabilities from a mental health perspective in making sure that he goes to court and an order is not made without his without him being appropriately informed, but also without him being able to get the appropriate support at court. For many services in Queensland, and I do note that I do understand that there are some interstate services who have registered for this webinar, our legislation is relating to the Queensland model, so it may not be all relevant information to you, and you may be able to glean some different ways or different ways of thinking from this webinar about how you may address your clients who face domestic violence situations and court processes. But in Queensland, there are a number of services which work collaboratively with the duty lawyer services across the state. Legal Aid Queensland in Brisbane, our domestic violence team, the Violence Prevention and Women's Advocacy team, while we support aggrieved persons, we have a social work team which assists women through that court process. We have Men's Line, who has a strong presence in the southeast Queensland region to provide information and support to men living with violence or using violence. And what's very important, and another thing to do with your toolkit, is that while this is tips about how to support Hugh, this is a tip of what you need to do to add to your toolkit and to your services toolkit. You must identify resources and services which are available to you and partner with them and make appropriate referrals. Most social work services and community legal centres who work in the area of domestic violence have referral pathway programs. Legal Aid has a referral pathway program. As I understand, some other community legal centres like Caxton also have referral relationships. And if you do not have relationships in a multidisciplinary approach, I strongly recommend that you talk to your senior lawyers within your teams or within your services or within your law firms to actually develop and identify a referral pathway to make sure that you can provide your clients a warm referral to an appropriate support mechanism for them. An example here is DV Connect and Men's Line. There are also organisations like Relationships Australia and vulnerability-specific legal services, such as the Aboriginal and Torres Strait Islander Legal Service or the LGBTI Legal Service. These are the things that you want to consider when partnering with your client who may be living with family violence. The next step is quite important. As a solicitor, you must identify their needs. Is Hugh seeing his children? We don't know if Hugh has children. We don't know if Hugh has alternative accommodation. Does he have alternative accommodation? What options of alternative accommodation do you have? Do you have a relationship with a homeless person's service within your region to partner with, to provide a warm referral for Hugh or someone like Hugh to make sure they have a roof over their head? A big trigger for contraventions of protection orders are situations where a person has nowhere to go and they're ousted from a property. It's very high stakes, and people do often breach because of a lack of accommodation or fear that they must house their abusive partner, or alternatively, the abusive partner feels that they have a right to remain in the home despite an order. You might need to ask questions about whether or not they have a bank account, access to money, Centrelink and identity documents. You may also need to consider, is your client's details correct on the court forms? Do you need to assist the court in line with your obligations pursuant to the Australian Solicitors Conduct Rules, in line with your if you are a legal aid preferred supplier, you also have obligations pursuant to the best practice guidelines around supporting clients who either are living with violence or are using violence. And you have an obligation to inform the court of any language barriers that a client may be living with, whether or not there are significant safety concerns. For example, what Hugh may tell you is that there's been a number of threats made to him about his safety if he attends court. You may need to assist Hugh in advising the court that while he is the respondent, he is very concerned about his safety about attending court. That also may lead into his mental health and capacity issues, as we've identified that Hugh is someone who lives with schizophrenia, and accordingly he may have issues around dealing with the court system, and his ability to comprehend the system around him may be impacted. There may be other cultural issues. And I also would like to bring to everyone's attention gender diversity issues underneath the LGBTIQA banner of concerns that affect people living with violence. On this point, it isn't an uncommon experience as a domestic violence duty lawyer to see people use a trans person's dead name in a court document as a way to demonstrate power, control, and emotional control of a person who has transitioned. I would strongly recommend that in the instance where you're assisting a trans person, whether they be male or female, it's irrelevant. But if a person has been referred to by their dead name, that is the name that they have left behind, that is not their identity, that is not who they are, I would strongly recommend you support your client in writing a letter to the court to inform the court of their true name and of the name in which they would prefer to be referred to. It is incredibly abusive and controlling for a person who identifies as trans to be referred to in their dead name, and it is a further step that people use to dominate and control a former spouse in these circumstances. It sounds pretty horrific, and it absolutely is, but that is a very, very real issue when we talk about gender diversity in the domestic violence space. Before I get onto this slide, I will highlight underneath the language concerns of the previous slide, there is a direction around magistrates' courts having to obtain interpreters where there are language barriers. I strongly recommend any lawyer or support person who assists clients to make sure that they or their service have a draft letter to provide to the court to inform the court as soon as practicable about language issues which may prevent a client, firstly, understanding what's happening at court, secondly, having the opportunity to understand legal advice that may be provided to them, and thirdly, preventing them actually engaging in a process where they may be identified inappropriately as a respondent when they could in fact be a true aggrieved. That means that the person who has the language barrier may actually be the person who is most in need of protection, which in accordance with sections 3 and 4 of the Act, we must consider as officers of the court to making sure we bring that information to the court's attention. Coming back to this slide, always, always, always support your client to be on time, to bring their court documents, and to bring any supporting documentation, including confirmation of counselling appointments, confirmation of doctor's appointments, particularly where health factors are relevant, and that includes issues of capacity, and any confirmation of any health or capacity or other issues which may impact on the outcome your client may achieve at their first mention or on their first mention. These things include where a person has short-term memory loss, situations where a person is not compliant with their mental health medication, which means they may not possess the ability to understand the impacts of an order, and that may include both an aggrieved person, where they benefit from the protection, as well as a respondent who may have an order made against him or her, and he or she has limited capacity to understand and comprehend what the orders mean and how it may affect him or her in the event of a contravention. As solicitors working in this space, it's not like working in certain other areas of civil law. This is about safety and making sure that we address issues of risk, and the best way that a court can assess risk and also make appropriate referrals or orders to make sure that people attend court in the future. For example, if capacity is an issue and we know that it's an issue and the Office of the Public Guardian hasn't been informed of an application being made against one of the people that they hold legal decision making for, that person doesn't have capacity to consent to an order or participate in proceedings. And if a court makes an order against that person, it is an appeal point. And what we don't want to do, and what we all are here to do, is to assist the court in a way in which promotes safety, which promotes information sharing so far as it's permitted pursuant to your obligations to your client, your obligations to the court, but of course your obligations pursuant to the Australian Solicitors Conduct Rules. So, given what we've just talked about, we've had a conversation with Hugh. Hugh has told us he has 3 children. They're aged 3, 5 and 7. The children were with the parties at the time of the incident. So the children were what we would classify as be exposed to domestic violence, and they may have witnessed domestic violence. And there may be referrals made by the Queensland Police Service to the Department of Child Safety. There may be referrals to other services as well. And we've identified that Hugh and Kate are involved with Mercy Services, who are assisting the family as part of their intensive family services referral from Child Safety. Hugh has also told us that he's not compliant with his treatment plan for his mental health conditions. And I apologise, there's an error there. Hugh has not been charged by the Queensland Police Service. So the good news here for Hugh is that he hasn't been charged with strangulation. However, there are a number of other issues that you need to deal with in line of what we've just talked about around informing the court about issues that may affect Hugh, about his capacity, and you may need to seek permission from Hugh to make a notification to Mercy Services to tell them what's going on. If a protection order is made against Hugh, whether it be on a temporary or a final basis, that protection order may impact on his support and his assistance from intensive family services, which will affect the family unit, which will affect his ability to be held accountable for his behaviour, but also to demonstrate change and be given the opportunity to grow and learn as a parent from the situation. That being said, in most courts, Hugh would be looking down the barrel of having a comprehensive protection order being made, which would preclude him from spending time with the children unless it is in an agreement in writing by the aggrieved or with the aggrieved, or in compliance with an order of a court, or pursuant to the supervision of the Department of Child Safety or other service. If you know that he's involved in something like intensive family services or some kind of intervention that's not the child safety team, but the level below, it's going to be so important that Hugh is provided the advice and support to ensure that that service provider is informed of this so that they can make the appropriate steps to make referrals for Hugh so that further action from the department is not taken. It is imperative that you give that advice and you partner with Hugh from a practical sense to ensure that Hugh and inadvertently Kate are provided the services. Someone like Mercy or Churches of Christ, who are services which I see very regularly in the southeast Queensland region, assisting people like Hugh and Kate, they need to know this information so that they can make appropriate assessments of risk, which they have to do in accordance with their legislative framework underneath the child safety legislation and their requirements of being a mandatory notifier, but also to make sure that Hugh is supported, Kate's supported, and the children are supported. The leading social work and psychological data that we see, that Steph and I see, indicates that children as young as 18 months show behavioural changes from being exposed to domestic violence. We're dealing with children of the ages of 3, 5 and 7. It is without question that these children have been affected by family violence, and it's about making sure that you partner with your client to ensure that he or she is supportive of any step to assist the children in dealing with their trauma, as well as supporting both parents through the trauma, whether they be the perpetrator or the victim of such violence. So I have said, how can you help Hugh now? You need to get permission again to contact Mercy. I would strongly recommend that, in line with your confidentiality principles of the Australian Solicitors Conduct Rules, that this is not a generic, I can speak to anyone, I've got the authority to speak to anyone. It is a specific authority that you receive from Hugh to discuss the protection order application, which includes disclosing the document itself to Mercy Services. There are risks in doing this, but there are risks in not doing this as well. If you come across someone like Hugh and you've identified all of these issues, you should absolutely be using that referral pathway that, if you don't have today, I hope that you will have it by this time next week, because this is that referral pathway that you can help Hugh get engaged with legal services to give him the advice that he needs before things start happening with the Department of Child Safety. As you know, the horse is already bolted, to be quite frank. However, if you support him and if he's able to give consent and you're satisfied with his ability to give consent, I do strongly recommend that you get that authority in writing. You make the approach with Mercy to make sure that they can partner with Hugh, or they can ensure that they get an ancillary service provider to support Hugh. The biggest risk for Hugh right now is that he may get ousted from the property. He may be facing homelessness. He's already non-compliant with his mental health records, with his mental health plan. There are so many other risks, which of course informs the court about the risk assessment that they must take about what is the risk towards the aggrieved and the children. Hugh is at risk to himself, but he's also at risk from the court's analysis about what factors they must consider in making a final protection order and what orders they may make. If Hugh has got support services around him, there is a better chance that there might be some steps taken or a slower approach taken by the court. It's not a guarantee, but Hugh has the opportunity to slow things down before a final order being made, to make sure that he's engaged, make sure that he's going to be held accountable for his behaviour and for his actions, and be held accountable for some of his health outcomes. No lawyer can save the world, and I think we all understand that. If you're listening today and you work in this space and you're interested in this area, you know that Our clients must be empowered to make the wrong decisions as well. That's a crucial part of what we do in domestic violence. People make the wrong decisions. We have to give them the information, and this is what you would be doing to Hugh. You'd be giving him the information, and that information is for himself. Now, because Hugh has those issues around being non-compliant, what Mercy and Churches of Christ and similar organisations have is that they can actually engage with Hugh's mental health support worker if he has been assigned one, his general practitioner if he has one, or any other allied health practitioner. For example, if we haven't talked about Hugh's age, if he's under the age of 25 and with his children of the ages, that's very, very possible that he's got those 3 children at those age brackets. But if he's under the age of 25, he would be dealt with in the public health mental health system very differently because he's technically an adolescent. That is something to very much consider about when you're helping Hugh and what services are available. Know your limitations of your services. Are your services and support services age appropriate? Are they culturally appropriate? Are they gender appropriate? Those are the things that we must consider. And by contacting Mercy, you're engaging with a service who might have all of this information and all of these support services for your client all ready to go. This is, and I do note that this is a very unique case in that we've got an intensive family services unit already assisting the family. This is not the ordinary case, but it's something that I can say I see quite regularly. Now, Mercy may also be able to come with Hugh and come with Kate separately to court to provide assistance to both of them. That means that they may be able to provide support people who can sit at court with them. DV court days are notoriously long in certain courts where they have enhanced or specialist domestic violence duty lawyer models. I would also take this opportunity to remind you that a protection order doesn't mean that he cannot see the children, but it may place safe boundaries around how and when he spends time with children. I've said this once, I've said this twice, and I'm going to say it a third time. I strongly recommend that Hugh obtain legal advice about the difference between DV and broader family law issues, which may include child protection issues. It is a discrete area of law. Please make sure that your service have developed strong relationships with appropriate service providers, which may include legal aid or preferred suppliers of legal aid. Ooh. Sorry, there we go. Now, you may have heard from my introduction earlier that I'm not from Brisbane. I grew up in central and western Queensland, in the towns of Middlemount, Blackwater and Rockhampton. I understand that those people who may be listening today from Cairns, from Townsville, from Mount Isa, or further west, Longreach, I accept that the domestic violence duty lawyer is not a service which is available in every court. However, each court has a different model of duty lawyer, and it's best that you approach your local courts that you will foreseeably assist clients with, and you identify what model of assistance is available to your clients who face domestic violence proceedings. Whether they are aggrieved, whether they are respondents, it is crucial that you identify this information, because this will help you make the appropriate referrals, build relevant relationships, and together put a toolkit which is geographically appropriate for your clients. I'd like to highlight that the DV specialist models include Townsville, Southport and Beenleigh. There are enhanced domestic violence duty lawyer models in Brisbane, Sandgate, Redcliffe and Caboolture. They're just in southeast Queensland, as I do note that that's a significant number of where our registrations are. And there's also a number of DV duty lawyer models in various locations around the state, which is a legal advice model. Under all models, right of a domestic violence duty lawyer exists to appear. However, in a specialist or an enhanced model, it's more likely that a duty lawyer will appear, because in the legal advice models, it's not a requirement. It's about information, advice, what options people are doing, and that's actually a separate assessment made by the duty lawyer in line with their obligations underneath the domestic violence duty lawyer model, which they're prescribed to conduct themselves with. That's a separate issue for today. And ultimately, this is why it's important to speak to your local court and identify what options are available for your client in your geographical area. Become familiar with your DV support services in your region. Build relationships and a referral framework. For those in Southeast Queensland, definitely get in touch with Legal Aid if you do not have a referral pathway. Contact Caxton Legal Service. They also have referral pathways to their service. And there are a whole raft of other services, including the Gold Coast Advice Bureau, the Pine Rivers Legal Service, who are ready to build relationships, who want to build relationships. The Women's Legal Service, it's very rude of me not to have already said that, but the Women's Legal Service provide a fantastic service statewide to vulnerable women, and it's important that you build those relationships, because even for me, as someone who has worked in this space for a number of years now and been with Legal Aid for 3 years, I cannot impress on the importance of building relationships, respectful communication frameworks with your colleagues, because they will help you at different times to understand, to make change, to help represent clients in the most appropriate way, and also model the advocacy styles that we need in this court to make sure we meet the objects and principles of the legislation. That is, that we assess risk, we consider vulnerability, and we ensure that orders are made which minimise disruption to people who live in fear and are at risk of living with domestic violence. So, a minor discussion point today. You've heard me talk repeatedly about our ethical obligations when we're faced supporting clients like Hugh. What are the risks? I'd like you to draw your thought back to the first slide, which refers to Hugh's the allegation against Hugh that he was strangled. Now, this incident occurred at a Queensland rail station. There's a fair chance that there's CCTV. Now, what's unclear on the material is that whether he's being charged, whether he's going to be charged. So any step that you take with a stakeholder from the Queensland Police Service, it would be critical to be very careful about the language that you use. Even if Hugh walks in and says, yes, I did it, I did all the wrong things, and I'm very, very sorry. I love her. Love is not an effective risk management tool when it comes to discussing this sensitive area. We need to look at what practical steps we can build in around our clients to address the issue of risk. That means counselling, that means doctor referrals where there's issues of health which may impact clients and their decision making. Other risks. Well, we've identified that Hugh is someone who actually we might have a question about his capacity. If he's someone who has borderline personality disorder and schizophrenia that we know of, and he's non-compliant, we don't actually know what symptoms that means that Hugh has. Does he have short-term memory loss? Is he quick to reaction? Does he present with psychoses? Does he present with a slightly higher level of fear, or is it full-blown paranoia? We don't know this information. So if you have a client where you have some concerns, you need to start thinking about what do you have in your toolkit where you're helping clients living with violence. What do I have in my toolkit that can help cover myself and help me think about the issues of risk and about whether or not I can get that confidentiality waiver from my client. Do I need to fill out a capacity check sheet? That's a risk for you. That is a very real risk, because if you don't inform yourself or turn yourself to those ethical questions about, well, hang on, does my client in fact have capacity, and then you take action, well, there's potentially some professional misconduct allegations that could be raised. I'm not saying that it's likely, but it's something that you absolutely should consider. Now, other risks. Well, you would have heard me say earlier, we have to empower people to make the wrong decision. Hugh may not want to take your advice. He may not want to assist you in, assist himself in going to court, telling the court what's going on, telling the court that he's got some mental health issues, that he's trying his best at the moment, but it's all too much. He's got some substance abuse issues. And then what do those risks mean to Kate? As practitioners in this space, we must go back to the objects and principles of the legislation. We must look at the Australian Solicitors Conduct Rules and remind ourselves of our professional obligations. As solicitors, if you do aspire to, or if you are working in DV, it's not about going into court and saying, oh, but this and that, and, you know, he's a vulnerable guy. So's Kate. Kate's incredibly vulnerable. She's got 3 young kids under the age of 7. There's potentially a history of domestic violence between the parties. There has been some history for Hugh previously. And also, what's Kate's history prior to meeting Hugh? There are other issues. What's going on in Kate's life? You know, we don't know all of this information, and when we act for people, whether they be aggrieved or respondents in domestic violence, I strongly recommend that you review the best practice guidelines of Legal Aid Queensland. I have provided some links towards the end of the presentation, because these are the risks that you must consider in how you conduct yourself as a solicitor, and how you are respectful to your client. Now, what are the opportunities in this? Well, working in domestic violence, you are presented with an opportunity to work in a multidisciplinary approach. There are very few areas of law outside of domestic violence, child safety, and, if I'm honest, homelessness, where you have that opportunity to have a multidisciplinary approach to address systemic, social and cultural issues that may be impacting on a client's life. That means that you have the opportunity to engage with the legal fraternity around you very broadly. You can identify mentors, you can identify colleagues, you can identify barristers that you respect and know who you can talk about these ethical conundrums that you face periodically with. This helps you and will help you be a better lawyer and better deliver services for people like you. I know that Steph and I worked for a number of years in the Brisbane Magistrates Court, and if we didn't build that respectful relationship where it's not about having an argument, it's about identifying what are the issues. What are the issues in dispute? How can we minimise risk? What is going to be the most appropriate order in the circumstances when considering our obligations to the court, to our clients, and to the legislation. We are not to mislead a court, ever. Just because it's in your client's best interest, going and filing that cross-application is not always the best option. It's about looking at what are the issues in the relationship, identifying the trigger points, and addressing the symptoms, if those symptoms can in fact be addressed. Now, building your own toolkit. Develop your legislative precedents. I have a litigation cheat sheet where I have all of the relevant bits of legislation on a tick box form, which I created myself. It's not a legal aid document, but I created it myself because I knew that sometimes when I was appearing in front of the magistrate, which I was unfamiliar with, sometimes I needed that quick reference guide of what does Section 8 say, what does Section 57 say, what does Section 62 and 63 say about our store orders. Those are the things that are important to you. You may wish to develop that yourself as well. If you're at a service that does provide legal representation, that's the kind of toolkit that you want. You want something that's practical, that can sit on the file, that can demonstrate what your submissions have been in court. I highlight them, I cross them out. It looks like cat scratch, but it helps me write my file note afterwards. Take some time to reflect on the Australian Solicitors Conduct Rules today, and also take time to consult the Legal Aid Queensland Best Practice Guidelines, particularly the ones that relate to experienced domestic violence and sexual violence. There's also guidelines for dealing with respondents as well. I bring to your attention dealing with those people who've experienced domestic violence and sexual violence because predominantly that's the kind of people that you're going to see. However, those toolkits are available. I strongly recommend that you reflect on your obligations pursuant to those best practice guidelines, whether you're a legal aid preferred supplier or not. If you don't have your own best practice guidelines, whether or not you have capacity to develop your own or adopt the legal aid ones as a tool to refer on, I strongly recommend you do so. Consult with toolkits for capacity, such as the New South Wales Law Society Toolkit for Capacity. That's my favourite one. That's my preference. Okay, that's something that I use to assist me in my practice. It's just got the information that works with the way that my brain works when I'm dealing with clients who've got capacity issues. There's also some guidelines from the QLS, which I also have on all of my files around dealing with people with mental incapacity issues, and I strongly recommend that you familiarise yourself with it. If you've registered today, I do understand that it's more than likely that you're part of the Community Legal Centres network, which means that capacity is an ongoing issue for everyone here. That's important. Take the time and consult with and develop your toolkit. Now, takeaways. Know the basics of the legislation, everyone. Build your networks, identify your key stakeholders, and support your client in making those connections, and build your toolkit. Finally, a point on self-care. As practitioners in domestic violence, we see things that most people don't. We're part of a community of professionals who deal with parts of life which can be confronting, which can be upsetting, and sometimes can cause us to revisit our own trauma and conversely deal with vicarious trauma. Every community legal centre, as I understand, is covered with an EAP service. I also bring to everyone's attention that that's not just for you. There's also, as long as you've got a practicing certificate, an EAP program with the Queensland Law Society, and I recommend that if you are not comfortable with using the service which delivers the service to your employment body, that you consider using Legal Aid Queensland, Queensland Law Society's EAP program. And if that's not right for you, if you've got your own, by all means go and talk to that person periodically. It's imperative that you take care of yourself as you work in this space, because it does have an impact on you, and often it has an impact on you before you realise it. So remember, as practitioners, we must take care of ourselves to make sure that we can take care of our clients.
Thanks very much, Jason. That was terrific. We've got a few minutes for questions. If you'd like to ask a question, there's two ways of doing it. You can press the button that looks like a hand, and I will try to unmute your microphone and you can ask your question, or you can type your question into the box on the dashboard at the side of your GoToWebinar screen. A few people have sent in questions in advance, which is another way of asking a question. So we might start with one of those. One of the interesting questions that was sent in was a question asking about how you can best support people in your client interview when you're asking questions of them, how you can get that information from them, what sort of language do you use, or what kind of non-verbal communication do you need to be aware of to best get information to and from people in that interview process.
It's a really good question, Steph, and thank you. I think it was Lauren who sent that one through.
That was from Barbara.
Okay. It's a really important question. I'm male. I'm also, I don't believe there's actual video of me talking, I'm not sure. I'm 6'4", and I'm built like a front row rugby player because I am a front row rugby player. So physically I'm quite imposing. So when I speak to clients, for me it's a lot about my non-verbals, about making sure that my body positioning isn't about using power stances or anything like that, that I adopt an open body language, that I adopt respectful, practical language that means something to them, and adopting language that isn't legalese. I must be conscious of my gender and the fact that my gender creates a power imbalance. That is the way that the world is. I acknowledge that as a white male, I experience privilege at the highest percentile in the community. And accordingly, I must conduct myself in a way which is understanding of that point in privilege. With your voice, tone, intonation and pace, it's about modelling appropriate, respectful behaviour with your colleagues, with your key stakeholders at court, and with the people around you. When you meet with a client, be calm. If you've had a really full-on morning and you need an extra 10 minutes before you speak to your client, take the time, because appearing calm and in control of yourself and your faculties will mean that you have a much more productive meeting with your client than rocking in, being all flustered, because that's the kind of thing that starts to elevate people. So be conscious of their body language as well, around if they're escalating, what is their breathing patterns, are they perspiring heavily, looking at all of those non-verbal triggers. Are they looking at the glass panel next to you at court because they're concerned that the respondent is looking at them? Conversely, is the respondent looking at them through the glass panel near court? Because that does happen. And it's something that you just need to be aware of. With DV, when you're representing clients at court or in an interview process, it's about taking steps around safety and identifying, how did you get here today? Are you safe to go home? Would you like us to call you a cab? Do you have Uber installed on your phone? Is that an option for you to get to and from court? Adopting all of those things will help you communicate more effectively with your clients.
Another question goes back to the case study we had about Hugh. In that situation, if you're acting for Hugh or assisting him at least, even just on a one-off basis before his court date, and you're helping him to contact Mercy, you may be contacting them on his behalf, obviously with his authority. How much information would you be sharing with them?
I would be first talking to Hugh, discussing specifically the things that I would be communicating with them. So I would inform them that a protection order is being sought by the police, that I'm asking whether or not Mercy can attend with him to court on that day. I'm going to ask if Hugh, is there anything that may impact on Hugh's ability to understand the legal advice that he's receiving today. You need to make an informed decision based on your own risk assessment about whether or not you provide a copy of that protection order to them, because there are some pretty serious allegations in there. They're going to get it one way or another, is the answer.
Unfortunately, at this stage of the process, it's more about you getting information from Mercy, really, than you providing information to them. The information might better come from Hugh later on in the process.
And also it might just be saying, look, we've got permission to talk to you about your mental health, about what you're doing, obtaining a copy of the intensive family services plan for the court, because the court's going to want to see it, so that the court can make appropriate orders. So it's very important that it's more you're obtaining information to enhance your knowledge of Hugh, to make sure that Hugh goes to court with the relevant information, or alternatively partnering with you to make sure that the court gets that information. Now, what you also be advising Hugh is that you would strongly recommend that he be upfront with Mercy himself about the protection order, about disclosing the protection order, about giving them a copy of the protection order, so that Mercy can start helping him engage with the services that he needs to earlier, so that an order can be made at the earliest point in time, which addresses the issues of risk, but also minimises disruption to Kate and the children's lives.
Thank you. I apologise if we haven't gotten to your question today. We are starting to run short of time. I also apologise to anyone who hasn't been able to watch this webinar live. If you have a colleague in that position, please pass this on to them. We were oversubscribed for this webinar. Our webinar software package limits the numbers who can actually attend live, but the webinar will be available on our website shortly, along with all of the links to the resources and suggestions that Jason has made, and links to our other webinars in this series. Our next webinar will be happening on the 4th of February. Invitations haven't gone out for that yet, but please keep an eye out for that and other webinars in this series. As always, we thank Victims Assist Queensland for their generous funding under their Building Capacity and Domestic Violence program, which is enabling us to present this series of webinars with people who are respected peers in this field. Thank you very much for your attendance today. Have a good afternoon.